Mr. President, members of the legislature, I've been doing very important things in my office this morning. I figured that looking at what was on final reading today, it could be handled very competently by my colleagues, and that has been the case. But this is Nicole's bill. That's why when I said with such enthusiasm, yay, had I not done that, I might have gotten a bite when I returned to the office instead of that enthusiastic greeting that usually occurs, in which I want to continue. Thank you, Mr. President. Mr. President, members of the legislature, this is a very serious subject, and it's coming up at a time when people are still perhaps spent from what happened yesterday in terms of a lengthy debate on a serious subject to which most of the senators attended. But we must press on because that's our duty. This morning, Parson Carlson gave me a list of sayings titled, "Some Things I Learned on the Farm." They are pithy, they are humorous, but there is a kernel of philosophy and truth in every one of them. I told Senator Carlson that he would see some rhymes as a result. He just gave them to me, so you have to excuse the spotty quality. But some of them are going to apply to what we're discussing here. This is by way of an introduction, my part, to let you know what is coming. Here be things I learned on the farm. If they don't help, they sure can't harm. Read 'em fast or study 'em slow. Your mind will afterwards plow a straight row. Keep eyes open and ears unplugged. Truth should always be tightly hugged. Time for some quotes, I've had my say. On to the learning, up, up, and away. Don't name a calf you plan to eat. A name's for a friend, never for meat. Country fences should be horse high, up to the shoulder, not just the thigh. Also, it needs to be pig tight. Then a fence is 2/3 right. Finally, and this concludes the fence song, to height and tight, just add bull strong. Life ain't about how fast you can run, how high you can climb, how quick you can pounce. Life ain't about just having fun. Life's deepest secret's how well you can bounce. You like wise sayings? Here's a for instance. Keep skunks, lawyers, bankers at a distance. Along the road of life are many bumps. Keep life simple, plow round the stumps. Mortgaging a future crop is probably like saddling a spindly colt that's wobbly. Avoid being stung by heeding this factor. A bee is faster than a John Deere tractor. Buying a milk cow, you won't get bilked. If you keep in mind, she won't stay milked. That's all the time I had this morning. You know why I say some of those apply to talking about this morning? Because I will say again, Senator Stoutman has the best of intentions in my view. But as Senator Howard pointed out, there are things in this bill which are totally off the mark, and they produce a result contrary to what I think Senator Stoutman has in mind. I was stopped in the hallway the other day after we had discussed this bill, and the person who stopped me was a woman. She was livid, not at me, but about the fact that here's another thing that men are doing which places the focus only on a woman for a problem that is perceived by men.
1 minute.
Nothing is said about the father. No attempt is made to track him down. Always the burden is placed on the woman. If the man would assume his responsibilities, the mother might not feel in such desperate straits that she couldn't keep the child. But even if she did, there would be two people to deal with this problem because two people created it. I'm going to have a few comments to make about the drafting of the bill itself and maybe a question or two for Senator Stootman along the way. Thank you, Mr. President. Thank you. Mr. President, members of the legislature, the first thing I want to do is correct my good friend Senator Wallman. He said he's going to vote for this bill. Well, no, he's not. He can't vote for the bill unless it comes for a vote. And if the Speaker were here, I would ask for a ruling from the chair, not on anything Senator Wallman said, but what I would ask for a ruling on is the following. Since our numbers are diminished to such a great extent, could I go around and punch the buttons for every desk that's empty on this side, and we will presume that if that person is absent, he or she would have yielded the time to me, and then I can speak in that person's behalf. But I will not ask for such a ruling. I will, however, ask Senator Stootman a question or two.
Senator Stootman, would you yield to a question?
Yes.
Senator Stootman, I mentioned the other day that the existing law, which relates to abandonment and neglect of a child, is being amended to say that this section of law, meaning the one I touched on, is not violated, and I'm paraphrasing, if a mother acting in accord with this bill would give proof of her identity. Is that accurate?
Yes.
Now, must she make the declaration that she is giving up the child pursuant to this law at the very time that she brings the child, or could she make it subsequent to that, say 2 or 3 days later?
Senator Chambers, do you mean if she would bring the child to the hospital and then give her identity 2 or 3 days later?
Yes.
I think, according to the way we have this amendment, is that when the baby is accepted, at that time, we need to get the identity of the mother, and then in exchange for that, it would be that she would be not in violation of the abandonment and child neglect law.
All this says, if I read it correctly, quote, "It is not a violation of this section for a mother to leave a child who is 72 hours old or younger with a hospital staff member pursuant to Section 1 of this Act if the mother provides the hospital staff member with proof of her identity." It does not say proof at the time the child is relinquished.
Senator Chambers, you are correct. It doesn't state that it is proof. I mean that she must give proof of identity at the time she delivers the baby to the hospital. But I would have to check into Section 1. I'm not certain. I will have to research that a little further. But I see your point. But what you are trying to relay is that the mother could say, well, I'm not going to tell you who I am today, but I might come back in 2 days.
Or she could just panic, because a person who is included among the staff members who can receive this child is somebody who is involved with admissions, and that's on page 1 in line 5. And a person who is involved in admissions is just sitting at a desk, so she could just place the child on the desk. That would be the relinquishment. And there's nothing in this part that we're amending that says the identity must be given at that time. And if child abandonment and neglect are considered criminal, a criminal statute is strictly construed, and if there's no time frame placed in this particular amendment, one of the elements to the crime is not included, so I don't think it would be constitutional. But my time is up. I'll pursue it as we go forward, but I'm going to need some additional time. My questioning is not designed to attack Senator Stootman. He and I have an understanding that when either of us has a bill or takes a position with which the other disagrees, there's nothing personal involved in our opposition, but I want to state that for the record. Senator Stootman, before I ask questions, I want to say a bit more about what we were just discussing. In Nebraska, nothing is a crime unless the legislature specifically makes it so. There are no common law crimes in Nebraska. Under the common law, there are crimes such as burglary, homicide, theft, and so forth. But unless the legislature passes a specific law and criminalizes conduct, it's not a crime in Nebraska. When a crime is created by the legislature, the elements of that crime must be specified. Each element of that crime must be proved beyond a reasonable doubt when a person is accused and placed on trial, or the person cannot be convicted. Pursuant to the presumption of innocence under the laws of this state and the country, an individual need not speak a word when he or she is charged. The state cannot coerce, entice, pressure, or in any way cause that person to feel he or she must give evidence which can be used against himself or herself. And that is pursuant to the Fifth Amendment to the U.S. Constitution. So a person who is accused of a crime need never utter a word, and the state is required to prove that person guilty beyond a reasonable doubt without any assistance from the accused. And every element of the offense must be proved beyond a reasonable doubt. Every element must be present in the act for which the person is placed on trial. I'd like to ask Senator Howard a question before she leaves.
Senator Howard, would you yield to a question?
Yes.
Senator Howard, can child abandonment or neglect be prosecuted as a crime in this state?
Yes.
Thank you. So, members of the legislature, what we're looking at here is a criminal offense. And if you go to the bottom of page 2, you will know that it's a criminal defense because it's in Chapter 28, 28-705. And Chapter 28 deals with the criminal law. So, you are creating a defense against a crime, a defense against prosecution. But you are saying, in the absence of this defense, a person commits the crime of abandonment or neglect. So, if the mother leaves the child without giving her identity, proof of her identity, she is guilty of the crime of abandonment or neglect. But if a prosecutor were to bring the charge, the prosecutor could not show that this law establishes a time frame within which she must give proof of her identity. She could say, it was my intent to do so. And if you're going to make this a crime, as is proposed here.
Time.
Thank you, Mr. President. Yes.
Senator Chambers, you have heard just what I have stated, and you had brought that up if the mother had brought the child and put it on the desk and just left and maybe decided in 2 days that I better go back and tell him who I was. Do you think that we should allow for that time frame to happen?
Well, what I think is irrelevant to what we're doing here, because the court is not going to look at what you think or intend, what I think or intend, or even how we interpret this law. The court is going to look at the language in the law. And it is said many times, it will not read something into the law that is not there. It will not read something out of the law that is there. That its job is not to rewrite the law. And if the legislature intended a certain thing, it must state it specifically when you're dealing with a criminal law. So if you want to apply this, you should put language to the effect, and it still won't work, and I'll tell you why later. The mother provides the hospital staff member with proof of her identity at the time she relinquishes the child. But that still won't get it. However, that's the answer that I'll give to you at this point.
Senator Chambers, yes, you probably state that that still won't get it, but that is an improvement to it, to the bill. But if you say it still won't get it, what do you mean by that?
What I have done with the offering of this language is to improve the bill. We have a sow's ear. We have cut some of the hair off, the gristle. We've removed some of the bumps and blisters, but we haven't made it into a silk purse. So although we've improved it, we haven't made the silk purse. And when you ask what do I mean when I say that won't get it, I will need a bit more time than what I have here, but I will address it the next time I'm recognized.
Okay. Thank you, Senator Chambers.
We have at least 2 lawyers in the House that I can detect. And if I'm, somebody said that's about all I've got.
1 minute.
In terms of people. 1 minute, you said, Mr. President?
1 minute.
What I'm going to do is give a bit of lesson, which caused some people to ask that I teach a course or two at the law college, because I read things and pay attention. But in the 1 minute I have, I can't do it, so I will stop at this point and continue the next time I'm recognized. Thank you, Mr. President.
Thank you, Senator Chambers and Senator Persh. Senator Howard, you are recognized.
Thank you, Mr. President. Members, I would like to give my time to Senator Chambers.
Senator Chambers, almost 5 minutes.
Thank you, Mr. President. Thank you, Senator Howard. If we look at the existing law, and you must read every word in a criminal statute, at the bottom of page 2, the existing law says, any person who abandons and neglects. To abandon is not enough to make you guilty of the crime of abandonment. You must abandon and neglect the child. So even if she does not give her identity and she leaves the child with this staff member, she cannot be found guilty of abandonment if you cannot also prove neglect. And the mere fact of abandonment is not enough to establish neglect. Words in criminal statutes are not considered surplusage. Every word is given a meaning. And since the conjunction and is found between the words abandonment and the word neglects, abandons and the word neglects, those two are a unit. They are joined. You must have both of them as a. And by that I meant but I should say an element of this offense. And if you don't have that element, you can't prove the offense. Now, I'm going to read what the existing law says. Any person who abandons and neglects or refuses to maintain or provide for his or her spouse or his or her child or dependent stepchild. Now, somebody might try to say, is the giving over of the child a refusal to maintain or provide for the child? Not really, because the child is being placed in the hands of an entity which is going to make sure that every need that exists is met. If my child is ill and I'm not a doctor, I'm not required to cure my child. I've done all that the law can expect or require of me if I put that child in the hands of an individual or an entity such as a hospital or a healthcare facility where proper treatment can be given. That is as much as I'm required to do. So I don't see where abandonment is going to come in anyway, but that's what they want, I guess, as a hammer. So let me ask Senator Stoutman a question or two, if I may.
Senator Stoutman, will you yield to a question?
Yes.
Senator Stoutman, why is the issue of abandonment raised? And let me ask another question. Was it felt that perhaps the mere relinquishment of the child would constitute abandonment, and you wanted to offer a way for that not to be deemed abandonment?
Yes, Senator Chambers. I wanted it was my intent so that the mother was not abandoning the child and she would be not prosecuted for abandonment.
Okay. Now let's go back to page 1, line 7. It says the hospital staff member shall, without a court order, take temporary physical custody of the child.
1 minute.
Under existing law, is a staff member among the categories you named, which would be those who are involved in admission, care, or treatment of patients. If somebody in admissions does not want to take custody of that child, is that person guilty of some kind of offense under your bill, since it says that staff member shall take temporary custody? That's the question I ask of Senator Stoutman, Mr. President.
Yes, Senator Chambers, I think it is the obligation of a hospital staff member to accept any person if they are brought to the hospital.
Is the hospital required to admit me if I don't have insurance?
Yes.
Time. Senator Chambers, you are next, and you're recognized.
Thank you. Mr. President, now that we have another lawyer on the scene, I'm going to ask Senator White a question or two if he will yield.
Senator White, will you yield to a question or two?
Boy, did I make a mistake walking back in here, but yes, I'm caught fair and square. I will yield, Mr. President.
If Senator White hadn't sat down so forcefully in his seat, I would have known he was here, but I heard him hit the leather.
I need to learn how to be a little sneakier, it's clear.
Well, not sneakier, less noisy.
All right, I'll work on it.
Okay.
Better.
Senator White, is a hospital compelled under the law to admit a person?
Yes, under federal law, in an emergency situation, they are. Although, of course, as you know, Senator, a number of hospitals are been reported for violating that. But the federal law requires emergency treatment be given until they're stabilized, certainly.
Do you feel that this that we're talking about would be deemed an emergency treatment? I mean, an emergency situation that would invoke the requirements of the federal law? I'm
not particularly familiar with the specific federal laws, but if you have a parent who is under such pressure that they would turn over their child, I would definitely call that an emergency.
If the child is not ill, if the child is not injured?
No, I would call it an emergency because of the parent's mental state, Senator. So the child's health is at risk. If anybody, by the pressure of poverty, events, postpartum depression, drug addiction, whatever you have, is in that desperate of situation, yeah, I'd call it an emergency. And the child's health's at risk.
I think you hit the nail on the head when you said the child would be placed at risk, so it would attach to the child and not just the condition of the mother, but the child.
Oh, absolutely, I agree.
First. Okay, thank you. And I tend to agree with that. But now I'm going to go back to the bill and ask Senator Stoutman a question or two, if I may.
Senator Stoutman, will you yield?
Yes.
Senator Stoutman, we've gotten rid of the language that would remove liability from the hospital. They no longer are immune. Now, on page 1, starting in line 21, for purposes of this section, generally accepted standards of professional practice means medical treatment or care of the type, quality, and amount that a hospital staff person would be expected to provide according to the professional standards of care for hospital staff with regard to the medical treatment and care of infants. When it says a hospital staff person, that would mean any hospital staff person, correct? Who is involved with admission, care, or treatment of patients, because those are the ones you specified.
Yes, that is true.
Now, I don't know that there's a standard of care that is imposed on people who work in admissions. So does that mean the standard of care that would be on one who provides treatment going to be transferred to this person who is involved with admissions? Is that person going to be held to this standard of care?
The way I understand it, and the way my intent is that the hospital staff person that admits this patient needs to have that portion of it, in the admissions portion of it, that individual's standard of professional standards and care of the admission part of it.
But there are certain things required. If a hospital, going down to line 9, I will move that it be bracketed to the date mentioned in the motion. Members of the legislature, I think I ought to be a law school instructor. I really think I should, but I'm not going to. And I'm going to mention something that was given to me by a lobbyist, and that's not meant to be disparaging, but the other day I'd made a comment about a person doing something and saying the devil made me do it. So he sent me this little joke, and it involved a minister's wife who had broken the budget by purchasing a very stylish dress. So when she came home wearing it, the minister could not deny that the dress was stylish. He said, but honey, we just can't afford it. And you know how many times I've told you that when I'm tempted, I say, Satan, get thee behind me? She said, that's exactly what I said. And he said, it looks even better from this position than it did in front. So what I'm going to show here is that whatever angle you take to look at Senator Stootman's bill or the law that exists now, the bill is not good policy, and it will demonstrate how difficult it is to draft a bill of the kind that Senator Stootman has in mind. So let me go back to what I was talking about, dealing with the language that was put into the bill by Senator Stootman. Starting on page 1 in line 9, if a hospital staff member takes temporary physical custody of a child pursuant to this section, the hospital staff member shall perform any act necessary, any act. It could be a tracheotomy, it could be to set a broken bone, it could be any act necessary, and it must be taken in accordance with generally accepted standards of professional practice. And when it talks about what those standards are, we drop down to line 21, subsection 4 of section 1. For purposes of this section, generally accepted standards of professional practice means medical treatment or care of the type, quality, and amount that a hospital staff person would be expected to provide according to the professional standards of care for hospital staff with regard to the medical treatment and care of infants. Medical treatment. So whatever medically needs to be done to ensure the health of that infant, this person in admissions must provide it. And that treatment must be provided in accord with those standards governing medical treatment. And what is the highest standard? That which is imposed on a physician. So when we talk about these standards of professional practice, they generally, but not always, relate to a physician. Maybe there are those that relate to a nurse, but we don't have anything specified that would narrow this definition. But one thing we know, it can mean more than changing a diaper or putting a bottle in the child's mouth. If there's an injury, this person must treat it. If there happens to be a small hospital, no physician on staff, nobody who is going to be able to cut and paste, nip and tuck, sew and stitch, then this person in admission has got to do it under this law. And I asked Senator Stootman, does this language which says that the staff member shall take this custody mean that there is an obligation created in the law where that staff member must accept custody? Senator Stootman said, yes, that is his intent. Once that duty kicks in, there are consequences that follow. Any medical treatment of any kind, nature, quality, amount whatsoever, it must be provided by that staff member who takes the child into custody. That's what the language of this bill says, and this bill implicates criminal sanctions. So it must be strictly construed. The court cannot read into the statute what Senator Stootman means if Senator Stootman's words do not say that. The regrettable thing about the discussion we're having here today is that there are so few of us here, which means that this issue is not taken seriously, or the discussion that we're having is not deemed to be very important because we're going to get out of here early. But that factor in and of itself is sufficient to show why we ought to be here. We're going to get out of here early anyway. Not only am I the oldest person in the legislature, Senator Stootman, I've been here longer than anybody else. I would be ashamed to let an old man show more stamina, more ability to focus and function than I, especially if I'm one half that old man's age or 2/3 that old man's age. But in any case, while they're coming. Bringing in the sheaves, bringing in the sheaves, they shall come rejoicing, bringing in the sheaves. But still we don't have many people here. But Senator Stootman is serious about his bill. I'm serious about my opposition. And this transcript is not going to say that Senator Stootman and Senator Chambers were debating this issue before a virtually empty chamber. I think the issue is one that deserves debate, and then it deserves to be killed as painlessly as possible, then granted a respectful burial. And unfortunately, I'm going to have to carry out all of those functions. Senator Stootman is a dear friend, Senator Whiteman. But as you know, if I'm a physician and he is a patient, and he is in a critical state, I may have to do a procedure which is going to add to his pain. Perhaps the administration of anesthesia would be such that his weakened condition wouldn't allow him to bear it. But under the circumstances, Senator Whiteman, I have got to act. So I take out my scalpel, or I take out my laser blade. And I wouldn't do it with a smile, Senator Stootman, although I'm smiling now. But if I were, it would be covered by my surgical mask. And then I would do what needs to be done, because sometimes to achieve healing, there must be some pain. And the pain is not always a bad thing. Senator Stootman experienced that when a butcher job was done, when he was donating some blood. At first there was numbness in his arm, but then because the nerve had been bruised, when the life returned, it was accompanied by pain. That was for the purpose of signaling Senator Stootman like an alarm clock. I'm awake. I'm alive. I can feel. I can be. And Senator Stootman should have said, thank goodness for the pain. But he probably reached for a Tylenol. Now, to tie that into what we're doing here, not every discussion that we have is filled with excitement. Not everyone is going to cause our juices to flow. But nevertheless, some that are very serious might even be boring because of the nature of the subject. This is one of those things which is going to involve criminal sanctions.
1 minute.
So we have to proceed with great care, in my opinion, take things step by step. And I have an obligation to make as clear as I can what my objection is, why I make it, and the flaws that I see in this bill. If it were enacted now, I don't think it would be implemented in the way that Senator Stootman envisions. So I'm going to do all I can to keep the legislature from ever taking a vote on it, up or down. Thank you, Mr. President.
Chambers.
Senator Chambers, 3 minutes.
Thank you, Mr. President. Thank you, Senator Langemeyer. I agree with all that Senator Langemeyer said, but I think because our children have absolute trust in us, Senator Langemeyer has an obligation to go to the hospital and get his son a little baby sister. Members of the legislature, and on a light note, we've used the term deliver, that the mother would deliver the child to the hospital. So Senator Parson Carlson, that completes the circle. It shows the symmetry in the universe if we look for it. In the first instance, it's possible, even under these circumstances, the hospital may deliver the child to the mother, then the mother may deliver the child to the hospital. What Senator Langemeyer pointed out in terms of the state of mind of somebody who may be so dejected, depressed, confused, or whatever, that she does not want the responsibility of trying to deal with this child. Maybe she feels she cannot. This bill's existence is not going to come to the aid of such a mother, because most people in this society, even the ones who consider themselves informed, will not know that this is even in place. She's not going to know that she has to give her identity if she leaves the child at the hospital. She's not going to know she has to get there within 72 hours. I'm not trying to be facetious, but suppose she can make it under the wire if she has a straight shot to the hospital in a car, but she gets tied up in traffic, and she gets there in 76 hours. Are we going to say that because she's 4 hours over the limit, then the law is not going to protect her where it should? Or that you must make this relinquishment within 72 hours? And most of us cannot tell you what we were doing 72 hours from this moment.
1 minute.
Now, if we well, no, we need longer than that to figure it out. But at any rate, there are strictures in this bill which make it unworkable. As Senator Langemeyer pointed out, and I'm going to tailgate on his, this bill is not going to stop the leaving of a child at Kmart or wherever that might have been. But if that should happen, the hospital will take the child once the child is delivered to the hospital. But under this law, we are creating a process. We are creating standards and requirements that must be met, which is not the case now. We are doing those things by law. So what Senator Stootman said earlier is totally irrelevant to what will happen under this bill. Thank you, Mr. President.
Thank you, Senator Chambers. Senator Shimmick, you are next, and you're recognized.
Thank you, Mr. President. Members, I would yield my time to Senator Chambers.
Senator Chambers, almost 5 minutes.
Thank you, Mr. President. Thank you, Senator Shimmick. The last time I spoke in a heat and a rush. And as I've said before, important or significant things should not be carried out in that manner. What this statute does is to specify requirements that must be met by a staff member at a hospital who receives the relinquishment of one of these children. First of all, in order for this law to apply, the relinquishment must happen within 72 hours of the birth of the child. How does the staff member know that that part is being complied with? And the staff member probably wouldn't even take the time to calculate it. But there would be no way for that to be imposed or enforced on anybody. Even if it were, this bill places on a person not trained in medicine or medical care. This bill places a standard on that person which would be found on a medical practitioner. That is not the case now. A new standard is being imposed by law. So a person who, under the current state of the law, could receive this child and then do the best he or she can. That situation doesn't exist under this law. We specified that that person shall provide any medical treatment that the child needs. That's not required under the law. Now, if you're not trained in medicine, you don't have to act like a doctor, but under this you better. And if you do act like a doctor, which you must under this law, you'd better behave and meet the standards of professional practice that govern the activities of this medical practitioner. That's unreasonable, but that's what this law says. If it took effect, we could be made a laughing stock, because we are expected to read these bills, to understand what they say, and to understand what we're doing. There are other bills that don't deal with issues this serious, so the consequences are not that grave if we do make a mistake or if we are not that careful and circumspect. But you are creating, or you're attempting to create criminal conduct, and you're doing it in a backhand way. You are doing it by trying to create a defense against criminal prosecution under an existing law. But it would be possible for a woman to relinquish a child without violating the existing law that makes abandonment and neglect a crime. I cannot say people haven't thought deeply about what they were trying to do. If somebody gave me the task of drafting a bill to do what Senator Stoutman intends to do, I'll tell him it can't be done. I'll tell him that can be done when the earth can be suspended by a rope of sand, when water without artificial assistance can run uphill, when God can create a stick with two ends. That's not unusual. But if you require God to create a stick that is 6 inches long that has only one end, even God can't do that. Tell God to create a stone too heavy for himself to pick up. That can't be done.